not represent Mr. Shin in the trial court. I wanted to start with the main issue, the only issue in this case, and I say this very respectfully because I think the world of Judge Fishburne, but I don't think he was aided mightily by the trial counsel, and I also say that respectfully. But I think that he ultimately erred in refusing to permit the defendant to cross-examine the alleged victim in the presence of the jury regarding her efforts to obtain this so-called U visa. You may have, you've looked at the record, you've looked at the transcript. It was really sort of a...
At the time of trial, the time of the defense counsel wanted to ask the question, what proof did defense counsel have that she had applied?
He certainly had a good faith basis to ask the question. He had the written statement from Ms. Young. He had the recording, which was never offered into evidence, unfortunately, a security recording. It was a camera that had a listening device on it from Mr. Shin's home in Jolton, Tennessee, where she could be overheard talking about the U visa, talking about her desire to get a green card in the United States, but in order to get that green card, she needed to secure that U visa first. So there was certainly a good faith basis to ask her those questions.
So the brief represents that she has had a valid U visa since 2019. And the brief actually states, it says, Ms. Young has a valid U visa, which is a non-immigration visa specifically designed for victims of crime who have suffered mental or physical abuse and are willing to cooperate with law enforcement. And then it cites a government website. The website itself, I think, the link to it, I think, at least I was able to overcome that. I see no support at all for the representation that she has had a valid U visa since 2019. Where did that come from?
Your Honor, the court had issued an order, and I responded to that order.
You did, and I'm not asking for anything other than where does the representation, where does the quotation in the brief come from? Because I think it matters.
Right. The quotation comes from information that I received from Mr. Shin's family. They were really involved in the case and had done their own investigation. I appended some of that to the sentencing memorandum that I cited to in this court, but when the court raised that question, I responded and said that I did not have support for it. Certainly. And asked the court to strike that from the brief.
Thank you, but the information itself comes from the defendant's family, the direct quote? Okay.
And when I tried to follow up on it, that site, unless you're a law enforcement officer, does not let you access that information.
Okay, so that's helpful. So defendant is withdrawing that representation.
Yes, I am withdrawing that representation, and I apologize
no need to.
the court.
I appreciate that. It seems to me there were two spots in the trial, really, that there was an attempted impeachment early on, and the trial court said, I don't really have a whole lot before me, because at that time she had, and at least in a pretrial hearing, denied that she had applied for a U visa. There was an assistant DA or someone in the DA's office who had testified to say that she had never worked with their office to apply for a U visa, which is a necessary prerequisite under the statute. And so it looked to me like the trial court at that point said, I just don't have enough here because I have to balance the need for cross-examination against the need to not allow speculative or wholly irrelevant evidence to go to the jury. And then when the defendant came forth with other information, including the recordings, the trial court reconsidered it and said, I think probably you have enough here. And obviously at this point in the trial, given what you've chosen to come forward with at the time, trial counsel, the best I can do is allow you to recall the witness. The witness has already testified, so I allow you to recall the witness. And the trial court did. Witness got back up on the stand. Maybe even arguably favorable to the defendant, since that's the only issue on which the victim now is being impeached. And it seems to me that there is no area in which defense counsel was not allowed to go. It seems to me there was no question that defense counsel was not allowed to ask. And it seems to me that the whole question then in the case depends upon the timing. Meaning that I got to fully ask about the U visa, I wasn't prohibited, there were no objections, the trial court didn't restrict me in any way in my cross-examination. And the whole question then comes down to, I wish it would have happened during her original cross-examination as opposed to recalling her later. Is that really what the issue is? Is the whole issue just a timing issue?
And I think it's an important issue, and it is candidly timing. And I know that you and Judge Ayers, and I don't know Judge Dyer's background, I don't know if he was a trial judge, but in the crucible of cross-examination.
Oh, he served on the Supreme Court, so we can.
She was there on the stand in the state's case, and there is a great benefit after she's given her direct examination to be confronted with what Judge Higgins, a federal judge, used to call the bone-crushing cross-examination, as opposed to having it pushed to the very end of the case where the jury has heard all the proof, and respectfully, they may have checked out a little bit at that point in time. I think that the immediacy of being able to confront and cross-examine her in the moment, in the right order. Yes, sir.
I get that, but as you're sitting here talking, I'm also sitting here thinking, if I'm a juror and I've watched this all play out and I see all this, and wait a second, all of a sudden the victim's being recalled for the sole purpose of being asked these questions that could be very damning towards her credibility, I could see where that may actually play more in your favor just by happenstance than it would if it happened a day and a half ago, or I don't know how long this trial was, but you know.
I think it was a 5-day trial.
Okay,
Yeah.
so if on day one she gets called, nothing gets asked, and on day 4.5, right before the jury gets charged, she gets back on the stand and you pick her apart on cross-examination, that's the last thing the jury's gonna see, right?
It wasn't me, but I think we may be ascribing a level of sophistication to, with all due respect, to a trial jury that they may have no idea why she's being advanced by the state at this point in time. They may think it's perfectly appropriate. And it could be prejudicial to Mr. Shin. They're wondering, well, why is she getting a second bite at the apple in this sort of bizarre half-a-loaf ruling? And again, I had great...
But at that point, she was asked about
Right.
her U visa status and was able to be, her credibility was attacked with that information. So,
But I think the problem is compelling a defendant to present any evidence at a trial.
Well, what about this, though? Because it strikes me that the error, if there is an error, isn't the error of the trial court. It seems that the error is the error of trial counsel, if there is one. And I'm not impugning error to anyone. But it seems to me that had trial counsel come forth with all of the evidence earlier at the original request, including the recording and things like that, that this trial judge would have allowed the cross-examination to have occurred at the time that I think we all agree, at least arguably, may have been more effective. And so where is it here? I mean, we can't reverse on the grounds of error of trial counsel. What did the trial court here do wrong? I mean, for example, it had no evidence before it at the time it was originally asked that she had a U visa, that it was relevant at all. He got the evidence later, but at the original time when trial counsel asked him, the trial court had none of that evidence. How did the trial court err early on?
Well, it was obviously an evolving situation. I identified with as much particularity as I could in my brief the 5 jury-out hearings that were conducted by Judge Fishburne. But I think it leaves us in the same place, and that is a criminal defendant is being required. He's basically had to waive a confrontation right and is being required by the trial court with sort of respectfully a take it or leave it, if you want to call her, kind of option, which is I think a structural constitutional problem with the way that the trial was conducted.
So the right of cross-examination, do you agree that it can be limited by the trial court to matters that are relevant and not speculative?
Yes.
Okay, so if we agree that the right of cross-examination is not absolute and that the trial court can impose requirements that questions being asked on cross-examination be relevant and that they not be purely speculative. At the time the original request was made to ask about the U visa, what is it that the trial court had before it that would have allowed it to make a finding that the questions being asked were not purely speculative? Because it had her testimony that she hadn't sought a U visa. It had the testimony of the DA's office that said, we're not engaged in this process. And it's important because that's a statutory prerequisite. And there was no other information before the trial court at that point, as it goes, that would have shown it that it was something more concrete, that it wasn't entirely speculative. And so at that point, could not the trial court have reasonably have said, I don't have enough here. If you want to come back, if you want to give me more information, I'm happy to consider it. And if you have more information, then maybe I'll change my ruling. It seems like that's what the trial court did. And so how was the trial court in error in doing that?
Well, I think one thing that this panel should take into consideration, when the victim witness coordinator testified on, I guess, the first morning of the trial, she conceded on cross-examination to one of trial counsel's questions that you don't really need the district attorney's office to certify this. Do you, was his question. She could hire private counsel, and in fact, I think there's enough in the record to show that she did, even by her own testimony, that she had consulted with this, I think it was Rowe, R-O-W-E, Weinstein, somewhere in Virginia. And in my sentencing memo, I attached that information that the family had given me. So there was that in the record, that you really didn't need a certification from the Davidson County District Attorney General's
I
office.
thought that was actually part of the statute itself, that you had to have that certification.
Well,
do you not have to?
Well, according to the testimony, I'm not saying that. According to the testimony of the victim witness coordinator, she was directly asked, well, can't you hire a lawyer and do this? And she said yes. So that's what I'm advising the court that the testimony was. There may be a statutory requirement that she was unaware of, but I just think there was enough in the record by the time Ms. Young testified that she should have been, that the defense counsel should have been permitted to do a fulsome cross-examination of her there at the appropriate time in the trial, not to be given this opportunity after everybody was packing up and ready to go home.
Was there, going back to it just to make sure I understand, and thank you for that, it really is just a timing issue. Is that right? Are there any other restrictions on the right of cross-examination that are being advanced?
Well, you're right, it is a timing issue, but it's also the burden that's placed on a criminal defendant to produce any evidence at a criminal trial, which appears to be a structural error in the trial. I realize that Judge Fishburne, excellent trial judge, trying to find a sensible solution, and you're right, this record is a mishmash. A way out of this came up with this solution to a almost intractable problem, but again, it unintentionally on Judge Fishburne's part has the appearance of shifting the burden to the defendant, which was eye-opening to me reading this cold record. I don't know how the panel viewed it when you read it, but it's certainly unusual. I would think Judge Greenholtz and Judge Ayers, in your experience, you probably never, when you were on the trial bench, had a situation where you suggested to the defense counsel, well, you probably should, put on some evidence.
Well, I don't know that I had that experience. I think I might have had an experience like this, though, where defense counsel says there's a piece of evidence that I would like to have admitted, and I'm moving the court in limine to allow its admission at trial. And we would engage then and I remember one case in particular where we'd engage in an analysis about whether the evidence is relevant and whether the evidence is excluded by any other provisions of the rules of evidence. In that case, I thought it was defense counsel's obligation as the party proffering the evidence to show why it was relevant and to come forth with evidence and, if needed, and with argument otherwise in support of the request to admit the evidence. And maybe I'm viewing the case through that lens, and maybe I shouldn't be, but maybe that's how I'm viewing it. So I don't know that I view it as forcing defendant to put on evidence, but simply to offer to the court reasons why the evidence that he wishes to proffer is relevant, and reasons why it's not speculative.
Well, and let me piggyback that.
Maybe that's what I'm
No, and let me piggyback that numerous trials, where the trial court makes a pretrial ruling, I'm not going to allow that in right now unless this happens, or unless this witness testifies to that, or unless this, and this happens. Many of those times, it is on the defense, in a way, you got to bring that out to make this piece of evidence more relevant, and once you do, then I'm going to let that in. Now, sometimes it is, hey, if the state opens the door, it comes in. But a lot of the times it is, this piece of evidence is being withheld unless you can show me something throughout your cross-examination or other proof you put on, defense counsel, that it should come in, which means that it's not coming in until later if it ever comes in. How is that any different? I think that's, in a sense, what Judge Greenholz is asking is a little different, but how is either one of those hypotheticals different than what we have here? And the court has said it's fine.
Well, I think it's very different. I use the phrase sui generis, where you have a trial judge, and I use the word advisedly, compelling a criminal defendant to offer evidence at a criminal trial. That's the distinction, and I think it's a distinction with a really big difference.
But was he really asking the defendant, or saying, defendant, you have to put on evidence, or was the trial judge not saying, if you want to impeach this witness with relevant evidence, you have to prove to me that it exists and how it's relevant?
But the timing of it and the way that it developed looks to an outsider like me as a defendant being compelled to put on evidence at a criminal trial. And when we set aside my affection for Judge Fishburne and what an excellent trial judge he is and what he was trying to accomplish, that's sort of the bottom line here. And that's the thrust of my argument.
Thank you.
Thank you very much. Thank you.
Good morning, Your Honors. May it please the Court. Garrett Ward on behalf of the State of Tennessee. Your Honors, this Court must affirm Mr. Shin's convictions for a variety of assaultive and kidnapping-related offenses because his sole issue on appeal, that the trial court inappropriately restricted cross-examination, is without merit. And I make that contention for two primary reasons. One is, from my read of the record and my understanding of the case law, the trial court acted entirely within its discretion in limiting cross-examination.
Let me just go ahead and interrupt you. And
certainly.
I don't think I'm comparing apples and oranges, maybe apples and pears. I'll admit that, okay? But how is this really different than a co-defendant taking the stand who has no deal with the state, but defense counsel at least getting to ask, do you have a deal? Again, I know it's not apples to apples, but it's not too far apart. I mean, it's someone who, because I'm with Judge Greenholz, I read it, the law, or at least the DA's office has to engage in this U visa process.
That is,
Okay.
and to address that very quickly, I believe the CFR is 214.14. It does affirmatively require the DA's office to certify that.
Right. So, I mean, so there is some you see where I'm drawing the comparison.
Certainly, Judge Dyer.
So if I'm a victim and I'm needing the DA's office's help with a U visa, how am I really different than a co-defendant who is looking to give testimony in order to catch a deal, right?
Mm-hmm.
And we get to ask that defendant whether we as a defense counsel know if there's a deal or not, because you and I both know in most cases they're like, oh, I got no deal. We all know there's a deal coming. There's just not one yet. But we still get to ask the question, right?
Certainly.
In front of the jury. So why don't we get to ask her that question without any real proof of it? Because it is possible that that's getting ready to happen.
And Judge Dyer, I sort of understand the thrust of your question. I don't think it's, I think the comparison to
It's apples to pears. It's not apples
It's
to
not,
apples.
it's not on all fours, and I think I'd like to poke at a couple of what I think are key distinctions. One is, and this is explained in, I believe it's the Romero-Perez case that is cited in both my brief and opposing counsel's brief, that sort of acknowledges that there is perhaps inherent prejudice to the defendant and the state just by sort of plucking at this string of the victim's immigration status, that regrettably, that may result in some attendant prejudice to the victim and the state, because asking them about this U visa necessarily exposes their transitory immigration status to the jury. So that's something that I think does make this different. We're dealing with a topic that to get at the U visa question, you have to expose this underlying thing, which has some prejudicial value. And I'd fully stand by the analysis. I think it's the Kentucky Court of Appeals in Romero-Perez. I fully stand by their analysis there. I think the second difference is, in Your Honor's hypothetical, we're dealing with a co-defendant, and here we're dealing with the victim, and I think that matters. A co-defendant, even if there is no deal on the table, like Your Honor said, we might all think there's a deal coming.
What about an unindicted co-defendant? Does it change your answer any?
Maybe slightly. My distinction perhaps has a little less force, and I take it that's why Your Honor changed the hypothetical slightly, but I think that the distinction still stands, because we're dealing, in that case, well, not a indicted defendant at that point. We're dealing with somebody where the idea is they have participated in this crime versus somebody who was a victim, who was a victim of it.
Okay, and that makes sense.
I think that changes things. So the combination of the difference in sort of who the person is and then this underlying fact.
So short answer, culpability matters. And the victim's not culpable.
Culpability matters, and the victim's immigration status in this case matters. So those would be the ways I would sort of draw a distinction between this and Your Honor's hypothetical.
Okay.
So I do think, given that it's entirely appropriate for the trial court, because there's rather abundant case law from this court and the Tennessee Supreme Court saying trial courts have jurisdiction, or not jurisdiction, have discretion to limit cross-examination, and that one of the things they can look to limit cross-examination is a line of cross-examination questioning likely to get to relevant evidence. And I'd suggest that at the time the trial court does limit cross-examination, and I'll acknowledge, like my friend on the other side said, this topic comes up several times throughout trial, but I think the main limitation on a cross-examination is the first morning of trial. Judge Greenholz, you spoke of sort of two spots. This is the first spot, in my view, and I believe Your Honor's view, that this motion is brought before the trial court, that it hears testimony from a victim witness coordinator with the district attorney's office who says we have not done any work towards helping Ms. Young obtain a U visa, which again, the testimony before the trial court, consistent with the CFR, is that is a necessary thing for the sort of prosecuting authority to do, because a U visa can only be obtained if the victim is sort of assisting or cooperating with prosecution. So nothing from the district attorney's office who would have to know about this application. That the trial court has nothing on that regard. And then the victim says, yes, I learned of a U visa after I made the allegations. And indeed, I believe the victim witness coordinator says that they are compelled to inform immigrant victims with less than green card status of the U visa process. So she says, I did know about a U visa, learned about it after I made the allegations, and indicates, at least at that time, I'm not certain if I'm going to pursue it or if I'm going to go back home to South Korea. And that's really where we are throughout all of the state's case in chief, throughout the victim's testimony, and critically for this inquiry, throughout the victim's cross-examination. So at this point, when the victim is being cross-examination, the trial court has absolutely no evidence in front of it that this questioning about a U visa is likely to do anything other than expose the victim's immigration status to the jury, which is not relevant to anything before the trial court.
But is the victim or any witness an overstay, or the fact that they might have some incentive to want to try to, remain in the country. Is that not, absent the whole U visa question, isn't that enough? Or is that a basis for cross-examination and to question that witness?
Perhaps, Judge Ayers, I think that is rather a complicated question to answer in this case because, candidly with the court, I think the sort of legality of Ms. Jung's presence in the United States at the time of trial, I found a little muddy in the record. She talks about having a couple of different types of visas. All of her testimony is obviously given through an interpreter, so maybe some stuff just gets lost in translation. But she does say she was legally in the United States when the crime happened. She indicates that at some point she left, went back to Korea, and has obtained some other legal status that is perhaps going to expire. So
She was legally in the United States at the time of trial, wasn't she?
that's my understanding, Your Honor. I just want to be candid that I found the record a little murky on this point.
Okay.
That's my understanding. Certainly, if this court reads it differently, I would cede to Your Honor's read of the record. But really, the trial court doesn't have any reason to think that questioning her about this is going to lead to anything until it does. And when it does have a reason to think that this might lead to something relevant, it says, well, in this case, you can absolutely question her. And in fact, when the trial court sort of revisits this ruling, which is during the defendant's case in chief, it all but says, I would have let you do this earlier if I'd known about this recording. It says some version of, I have information before me now that I didn't have when I didn't allow you to cross-examine her. And in my mind, that makes a difference. And I think that makes some degree of sense. The trial court here is exercising its discretion to limit cross-examination to only relevant topics. At the time this is first presented, there's no indication that this is going to lead to any relevant testimony from Ms. Jung, lead to any testimony that would, for sort of fair reasons, cause a jury to doubt her credibility. But then the defendant puts on this, or makes essentially an offer of proof, this audio-only one half of a conversation from an audiovisual security system. Trial court says that I'm concerned about the authenticity of this. I'm not going to admit it, but I'll allow you to cross-examine her because in this conversation, she makes a statement that is maybe a little more affirmative about considering getting a U visa than.
So your friend on the other side says, I think in part, this is a timing issue on the one hand, but the real prejudice here is in the jury seeing that the defendant has to come forward with proof to impeach the victim, that it's because of the timing issue. It's not naturally occurring during cross-examination, but looks like the defendant is having to recall the victim, having to affirmatively offer proof when the Constitution absolutely doesn't require that. Mm-hmm. I understand that to be essentially kind of the argument as to prejudice about why the timing matters. What's the response?
Certainly. At first, Your Honor, I believe I understood my friend on the other side to say that this was somehow structural constitutional error. That's a notion that appears nowhere in the briefs. It's sprung forward for the first time here on oral argument. But he does. There is some suggestion in the briefing that maybe this amounted to burden shifting, and I think I'd sort of push that notion away for two reasons. One is if a defendant wants to impeach a state witness, it's sort of always incumbent on them to do so. They don't have to, but if a defendant wants a jury to doubt a state witness's testimony, then they are entitled to, and indeed probably should, try to impeach them. Whether that's through cross-examination as is normal or here, I don't think the court's really doing anything that changes the burden on the defendant. The defendant wants the jury to doubt her testimony. When he gave the court sort of a good faith basis for suggesting that he could ask questions that would cause the jury to doubt the victim's testimony, the court allowed him to do so. But the court didn't really, I think, impose any additional burden on the defendant here. And I think really what this problem gets down to is when the defendant sort of comes forward with this evidence that makes this relevant. He mentions this recording during this first during sort of the first spot that Your Honor noted. He mentions in very briefly, he says, I've got this recording, doesn't introduce it. What is the trial court to do here? at the only point where it has a reason to think this is going to lead to relevant evidence, it lets it in. From my read of the record, it seems entirely obvious to me that had this recording been given to the trial court when the defendant was trying to cross-examine her, the trial court would have allowed him to. A defendant can't not offer make this essentially offer of proof, which I'm sort of in agreement with Your Honors that this seems fairly similar to things that happen in a lot of cases where a trial court says this piece of evidence doesn't quite meet this relevance, this threshold standard for admissibility, doesn't meet it for whatever reason. If a defendant wants to sort of is proffering evidence, he does have to show that it's admissible.
Can we go back to Judge Dyer's hypothetical that he posed to you at the very beginning of your argument again?
Certainly.
In that case, I think pretty routinely trial judges would allow a co-defendant to be questioned about the existence of a plea agreement, not knowing whether there's one in place or not. I could foresee, for example, in my experience, if someone had raised an objection, I likely would have overruled it, saying that's clear evidence of bias. I don't know what the answer is going to be, but we'll see what the answer is going to be. How do you distinguish Judge Dyer's hypothetical?
So I'll very briefly reiterate the two points I gave earlier, and then I'll endeavor to provide some further points. First, we do have a victim here instead of a co-defendant or an unindicted co-defendant, somebody who is still sort of potentially culpable versus somebody who was victimized.
I don't see that distinction clearly in my mind.
Certainly.
The presumption of
Yeah, it's
innocence.
still a witness. How is it different?
I don't see that distinction, but let's assume that that's just me and everyone else in the room sees it. What's the second point?
The second point is the notion that the Kentucky Court of Appeals mentioned in Romero-Perez that there is a danger of prejudice just by exposing the victim's transitory immigration.
And that's also present in Judge Dyer's hypothetical, right? It's like, well, you know, the danger of prejudice is here that I might be admitting to a crime later on, or I'm giving favorable testimony just to get a deal, and so naturally, that's to me that I don't see that solves it either. Just the inherent nature of immigration as it goes. Is there a third basis?
I mean, those were the two I offered to Judge Dyer's hypothetical. I think if I were to give a third basis, I would try to really pluck out what I think is something that a juror or anybody watching a trial might logically think when there is questioning of somebody who might potentially be culpable for this crime. That anybody reasonably, when that person is testifying, that we might think, oh, they have a reason to try to help the state. That's not hidden in some sort of arcane portion of the Code of Federal Regulations. Sure. Something that we all understand. Law and Order's been on TV for 35 years now. Something that a juror might commonly understand, that the defendant might commonly understand at all times, that he is sort of making statements to the police, cooperating with the police during the investigation, and then ultimately testifying. Here, we have something slightly different. We have an immigration mechanism that is only available to people of less than green card immigration status. Every indication in the record is that that our victim doesn't know about this when the allegations are made, that she's then informed about it, but then there are no steps towards pursuing that. And I think there's a difference between sort of maybe the intuitive understanding of maybe the existence of sort of the adverse process in the criminal justice system might make a potential co-defendant, even if they're not charged yet, want to cooperate with the state. That's a much more logical, intuitive leap for the jury, any observer to make, than to make that same leap here.
So Judge Ayers earlier, though, had asked you about the motivation to lie, and that if I'm seeking, some kind of immigration benefit by alleging the fact of a crime that didn't happen, and it seems to me to still be on all fours, because with the Judge Dyer's criminal defendant, the whole purpose is bias, motivation to lie. And here it's not much of an inferential leap to say if I'm getting a benefit, so it's not a plea agreement or favorable sentencing recommendation. Here it's I get to stay in the United States. That's not a very big intuitive jump. So why is it here from your perspective, like Judge Dyer's hypothetical, where the trial court could not have said I don't know how she's gonna answer, but that seems to me like you can ask the question.
So the criminal defendant in this hypothetical, at least my understanding of human nature, is basically always going to not want to be charged with a crime. Ms. Jung, our victim here, may or may not want to remain in the United States. There's not this certain benefit or potential certain benefit that cooperating with the state might give her. It may give her this benefit if she pursues it, but without any indication that she's going to, her cooperating with the state is not necessarily of any benefit to her until she goes to avail herself of this U visa.
But to Judge Greenholz, as he said numerous times in questioning both of you, as a trial judge, you go, I don't know how she's going to answer it, but let's see what she has to say. You know, why wouldn't that just be the case here? She could easily say, I have no desire to stay in the United States, so why would I be interested in the U visa?
So the trial court had a jury out hearing and did hear what she had to say, and
Well,
she gave essentially that answer.
I understand he had a jury out hearing. I'm talking about in front of
Certainly.
the jury at the time. I mean, why not just, hey, let's put all the cards on the table in front of the jury, let them hear it all and sort it all out, because she could I don't know what she's going to say, but it could go to bias. And so let's just hear what she has to say. And she can answer, yes, I'm looking for a U visa, but no one's promised me anything because this really happened to me. She could also testify, this really happened to me, and because of it, I have no desire to stay in the United States. I'm not looking for a U visa. I got no deal.
Mm-hmm.
How is that really, why don't we just let the jury hear it while she's on the stand and just move on at that point?
And
Just like we do with a co-defendant or a snitch or whatever you want to say. Any witness. You know, if we, you know, why did you not put it out there and move on as opposed to wait till the end and make, I will say this, I agree with you that asking a defendant to meet a level of proof and relevance, however you want to say it, before they can just put something out there is not making them it's not giving them an undue burden, like the state has the burden of proving guilt or innocence. That being said, they still should kind of be able to poke holes in the state's case with some fairness that's not requiring them to jump through a bunch of hurdles.
So I think my point, my response to that, Judge Dyer, would be to first say, I hope I haven't been inartful with any of my argumentation. If the trial court had permitted this questioning, that may have been a decision that was also within its discretion. We're talking about a trial court's discretionary decision here to limit cross-examination. I'm certainly not saying that had he permitted it, that the state would be up in arms and trying to appeal that decision. It made a discretionary call based on the evidence in front of it, if I may finish responding. It made a discretionary call based on the evidence in front of it, trying to balance this notion of prejudice due to transitory immigration status, perhaps the uncertainty of whether or not there would be any benefit or potential benefit to this defendant or to this victim, because it is dependent on her knowledge and intention knowledge of the U visa and intention to obtain one, and it didn't allow questioning at that point. But even if this court thinks that was beyond the trial court's discretion, I suggest that the error is harmless because the defendant was allowed to ask every question he wanted on recall.
I mean, isn't the answer just simply, and maybe this is what it is, and you've been saying it all along, and finally I'm coming up with it. Isn't the answer simply, we do know how she answered? The questions were asked in the jury out hearing. She said that she had not pursued the visa. Trial court heard it, concluded that it wasn't relevant, and because it wasn't relevant, it was out like every other single case in the nation.
Essentially, Your Honor.
I mean, that's what the argument is, right?
That's my point. He didn't, in the jury out hearing, he heard what she had to say, and it wasn't relevant. When it was relevant, he allowed the question.
And so there was no need to have the jury hear the same thing because it wasn't relevant until it became relevant.
Correct, Your Honor.
And then when it became relevant, the jury heard it.
Exactly.
Okay.
And I will tell you, General, your argument was artful. We're just pushing and pulling to see
Yeah.
where the
See
line
where-
is.
see where it goes.
That's all we're doing.
It's what we're all here to do.
Right.
Thank you, Your Honor.
Thank you. Rebuttal.
I used up
You,
all my time, but just very, very quickly. I think Judge Ayers sort of put her finger on it. You know, what would preclude, if you just strip away all of this, what would preclude a criminal defense lawyer from asking somebody who's here in the United States, either with a visitor's visa or something less than a green card, do you hope to remain in the United States and get the benefit of the U visa or any other immigration benefit? You could ask, that would be a good faith-based question just by the person's status. My understanding, Judge Greenholz made the statement that she was here legally in the United States.
She was on
And
a visitor visa, wasn't she? Wasn't she residing in South Korea and came back for trial on a visitor visa?
Yes, that was
she was
my
here
understanding, but
lawfully,
at some point in time, she had overstayed a visitor's visa, and that's what I was confused about.
Okay, I thought at the time of trial she was
She-
here on a visitor visa and was lawfully present in the United States.
And Judge Dyer, I thought your analogy was really apples to apples because you were channeling that Romero Perez case from the Kentucky Court of Appeals. And I'm not going to read it to you all, it's on page 16 of my brief, but the Kentucky Court of Appeals really spells out the danger of not being able to probe the bias that a witness might have if they're getting the benefit of something like this.
In that case, though, the the victim actually had pursued, and in fact, had filled out an application for the U visa. Is that right?
Right. But I think, and I know it's just something that was attached to, I think she was asked the question about this Virginia law firm at one of the many jury out hearings. And she did acknowledge that someone had directed her to that law firm, and that was the law firm that was supposed to be helping her. Well, I appended, because the family gave it to me, something from Facebook where this law firm in Virginia who prides themselves on having very high-profile clients made that announcement that they were representing her. So I don't want to disparage anybody. I think it's a fair characterization that she likely lied about her efforts to secure a U visa. Whether she had been granted that or not, she was actively trying to get a U visa based on the objective evidence. I know it's sort of outside the record, but a little bit inside the record. So I just think the rationale of the Kentucky Court of Appeals really sort of hits the spot, and thank you very much.
Thank
Thank
you.
Thank you.
Thank you both.
I'm good. Just got one more.
You good?
Yeah.
Okay. We'll call the next case, please.
State of Tennessee versus Gerald